The following presentation and any ancillary materials are general, educational, and informative in nature and should not be considered legal advice. Although we believe the information provided was accurate at the time it was prepared, we make no claims, promises, warranties, or guarantees about the accuracy, completeness, or adequacy of the information contained in this program. Immigration law changes regularly, and this program is not to be used as a substitute for your own study and analysis. Additionally, an individual's facts and the jurisdiction applicable to a particular case will vary and will affect an individual's options. This program should not be solely relied on in advising a client on how to proceed with his or her case. Padilla v. Kentucky, a landmark 2010 U.S. Supreme Court case, requires that criminal attorneys provide proper legal counsel in regards to consequences of a criminal case to the immigration status of their non-citizen clients. Immigration to the United States has steadily increased since the mid-1800s, and over the last decade, more than 1 million foreign-born people per year have become legal permanent residents. Until these legal permanent residents become naturalized U.S. citizens, they fall within the purview of Padilla v. Kentucky and have a constitutional right to proper legal counsel on how possible outcomes and resolutions of their criminal case may or will affect their immigration status. Every state has had an increase in the foreign-born population over the past 10 years, with 19 of the 50 states having over a 100% increase. Non-citizen clients are everywhere. This client base could be very lucrative and should not be ignored. The bottom line is that there are an estimated 21.7 million non-citizens in the United States. Note, this estimate is conservative because a high number of non-citizens live in the shadows. But it's clear, a properly informed criminal defense attorney can expand his or her practice to include this client base if they are willing and able to provide sound legal advice in regard to immigration consequences. That is the purpose of this video presentation. Your presenter is Gary L. Davis, founder of Davis & Associates, a law firm focused on the practice of immigration law in Dallas, Texas. Mr. Davis is a graduate of the University of Texas School of Law and is licensed to practice law in Texas. Additionally, he is board certified in immigration and nationality law by the Texas Board of Legal Specialization and has been practicing exclusively immigration law for over 10 years. He has tried hundreds of cases in immigration court and has focused much of his practice on deportation defense and helping non-U.S. citizens resolve immigration consequences of criminal activity. A frequently invited speaker at university, local, and national law conferences, Mr. Davis has been selected as a Rising Star Super Lawyer, published in Texas Monthly Magazine 5 times, and as a Best Lawyers in America 4 times. In Defense of Immigrants, Criminal Defense Attorney's Primer to Representing Non-U.S. Citizens. Why represent non-U.S. citizens?
As a criminal defense attorney, your job is to represent folks facing criminal charges. You work hard to minimize or avoid jail time, keep your client's costs as low as possible, the opportunities to keep your client's record as clean as possible going forward in their lives, and strategies for avoiding convictions if at all possible. When a client is a non-U.S. citizen, however, the counsel that normally would be very positive for a U.S. citizen may have severe immigration consequences to a non-citizen client. Representing non-citizens in criminal proceedings can be some of the most rewarding experiences that can be enjoyed in the practice of law. I know that from experience. No one wants to go to prison. No one wants to pay higher fees than they have to. No one wants to be on probation longer than they have to be. But for non-citizens, the stakes are even higher. Deportation from the U.S., loss of livelihood, separation from family, return to poverty or disgrace. For some, facing these consequences can bring more anxiety than the risk of spending time in jail. Winning non-citizen criminal cases brings a tremendous relief and joy to the clients and their families that is more intense than the relief U.S. citizens would normally experience. It is deeper as concern and anxiety for their futures and the futures of their families is relieved. Success in these cases leads to a tremendous amount of satisfaction to those who represent them and a future referral base for the attorney who is willing to undertake the task.
Padilla v. Kentucky.
So why does this matter to you as a criminal defense attorney? On March 31, 2010, the U.S. Supreme Court redefined the rights non-U.S. citizens can expect to have protected in criminal proceedings. Justice Stevens, quote, "The importance of accurate legal advice for non-citizens accused of crimes has never been more important. Deportation is an integral part, indeed sometimes the most important part, of the penalty that may be imposed on non-citizen defendants who plead guilty to specified crimes," close quote. With these words and with that decision, the court holds criminal defense attorneys accountable for advising their non-U.S. citizen clients of the possible immigration consequences of the possible outcomes in criminal court. That decision is Padilla v. Kentucky from 559 U.S. Supreme Court Reports. It was decided March 31, 2010. If you are going to represent non-citizens in criminal proceedings, you must familiarize yourself about U.S. immigration law.
Issues in representing non-citizens.
Since the amendments to the Immigration and Nationality Act, found in the Illegal Immigration Reform and Immigrant Responsibility Act of 1996, and in the Anti-Terrorism and Effective Death Penalty Act of 1996, the consequences of criminal activity to those who are not citizens or nationals of the United States have become severe. Some of those provisions, such as the definition of conviction, became effective retroactively, rendering counsel given in defense of criminal accusations that was accurate at the time into ineffective assistance. Changing the definitions of conviction, sentence to a term of imprisonment, aggravated felony, and other terms of art in the immigration statute has turned the practice of representing immigrants in criminal proceedings into a minefield. Those criminal defense attorneys who wish to represent non-citizens in criminal proceedings must become knowledgeable of the consequences of their counsel and the outcomes in those proceedings in immigration law. To do otherwise may lead to grievances and malpractice suits as a necessary prerequisite to seeking relief for ineffective assistance from a criminal court. In matter of Lozada, the Board of Immigration Appeals advised immigration attorneys who wish to file motions to reopen immigration proceedings on a claim of ineffective assistance of prior counsel must provide information about whether a grievance or other complaint has been filed with the appropriate disciplinary authorities against the accused attorney. The complaint is basically treated by the board as prerequisite to granting a motion to reopen. The Lozada case involved ineffective immigration representation. However, considering the recent Supreme Court ruling in Padilla, expect grievances and other bar complaints to increase against you if you're not informed about how to properly represent non-U.S. citizens in a criminal case.
Overview.
In this presentation, my goal is to arm you with the basic knowledge you need to confidently represent non-U.S. citizens in criminal proceedings and to recognize the potential pitfalls your clients may face with U.S. immigration authorities based on the advice that you give. In the first section, I will point out the main sources of U.S. immigration law, a brief overview of the agencies responsible for enforcing those laws, and some key terms to give background on the vernacular commonly used in immigration law as it relates to criminal defense. Next, I will discuss some of the most common criminal offenses that we see in immigration court to give you some ideas about why those offenses can become problems for our clients. I will then discuss the deportation process and options for non-U.S. citizens to avoid deportation, specifically the pitfalls to watch out for in the criminal case as they relate to the deportation process.
Main sources of law relevant to this discussion. U.S. immigration statutes.
Let me start now by listing out some of the main sources of law and the agencies responsible for enforcing that law that are relevant to our discussion. The U.S. immigration statutes are found in Title 8 U.S. Code, which is codified into the Immigration and Nationality Act. I will refer to this as the INA, and all references to any statute will be to the INA section. Also, you will find regulations in the Code of Federal Regulations in Titles 6, 8, 20, and 22.
Immigration law enforcement.
Immigration laws are enforced by several different agencies in the federal government. The main agency responsible for immigration processing and enforcement is the Department of Homeland Security, which is broken down into three different sections: United States Citizenship and Immigration Services, or CIS, is the agency responsible for adjudicating visa petitions, applications for green cards, and other immigration benefits applications. Most benefits processing is going to be handled by CIS. Immigration and Customs Enforcement, or ICE, which spends the most time in the news, is responsible for enforcing the law against those who have violated customs or immigration law. The attorneys for ICE are the prosecutors in removal or deportation proceedings. Customs and Border Protection, or CBP, includes the inspections processing at air and land ports of entry and the Border Patrol. The U.S. Department of Justice also is involved in immigration enforcement. The Attorney General of the United States has ultimate authority over whether someone will be deported or not. Probably not a high priority job for the U.S. Attorney General, but it is one responsibility of the office, and he or she sometimes does get involved in reviewing decisions of the Board of Immigration Appeals. The Executive Office for Immigration Review, EOIR, is in the Department of Justice and is the Attorney General's office that is responsible for operating the immigration courts throughout the United States. It is made up of those immigration courts, which are the trial-level judges. Cases are never reported from that court. Appeals from that court are to the Board of Immigration Appeals, which has some reported cases in the Immigration and Nationality Decisions Reporter. Appeals from that court go to the Federal Courts of Appeals and to the U.S. Supreme Court, which decisions can be found in the Federal and Supreme Court Decisions Reporters. The U.S. Department of State is also involved in processing immigration. The Secretary of State has ultimate responsibility for processing visa applications at the various U.S. embassies and consulates throughout the world.
Immigration terms of art.
U.S. immigration law is a legal bizarro world. Terms that are commonly used in a particular way, such as visa, conviction, and sentence, have very technical and frankly weird meanings when applied to U.S. immigration law. So let's take a moment to review some of these terms to put the rest of the presentation into the appropriate context.
Who is an immigrant?
An immigrant is anyone who is not a U.S. citizen or national who enters the U.S. with the intention to remain in the U.S. permanently. An immigrant can enter the U.S. either legally or illegally. Immigrants who have entered illegally are commonly referred to as illegals or illegal aliens.
Who is a non-immigrant?
A non-immigrant is someone who enters the U.S. with the intention of remaining on a temporary basis. This is the opposite of immigrant and is the technical term for someone who is in the U.S. after a legal entry with a visa. Students, temporary workers, international managers, international traders, or investors all come to the U.S. as non-immigrants for a temporary purpose.
What is a visa?
Many attorneys think that a person's visa determines whether or not they are legally in the U.S. This is not the case. A visa is actually a document stamped into a person's passport by an officer at a U.S. consulate or embassy outside the United States that allows the holder to seek entry into the U.S. A visa is categorized by the purpose of the entry. An F-1 visa is for students, R-1 visas for religious workers, H-1B for professional workers, and so on. The visa duration will vary depending on relations and treaties with the person's country of nationality in the U.S. A visa can last for up to 10 years, although a person with a visa might be admitted to the U.S. for less time than that. Remember, the visa is just an entry document. Once the person enters the U.S., the visa becomes irrelevant. What I don't want to have happen is for you to consult with a non-U.S. citizen and for you to ask them, let me see your visa. You open the passport, look at the visa, it's good for 10 years, and you say, you know what, you're good. In a nutshell, someone can have a perfectly valid visa but still be in the country illegally. Status is what determines if a person is in the U.S. legally.
What is status?
Status is a person's authorization from the U.S. government to be in the U.S. A person presents his or her passport and visa at the port of entry and is then issued an entry permit called an I-94. So a valid I-94 is what you're looking for rather than just checking out the person's visa. Now this is a good general rule for determining a person's status, but it doesn't cover all situations. For example, people with temporary protected status, TPS, or a pending application for permanent residence are authorized to be in the U.S. but may not have a valid I-94. When in doubt, you must consult an immigration attorney. Assuming everything is in order, the person will be admitted under a particular classification to match the person's visa and purpose for coming to the U.S. The classification and period of admission constitute a person's status to be in the U.S. Whether a person has a valid visa or not is not the issue. It's all about whether or not they are in status in the U.S. A person violates his or her status by not conducting themselves within the limitations of the visa he or she used to enter the U.S. For example, a non-immigrant in the U.S. on a tourist visa may have only been admitted for 3 months. However, if this individual remains past that time, the person will have violated their status and will become illegal, and at that point is subject to being deported from the U.S.
What is lawful permanent residence?
People who intend to remain in the U.S. on a permanent basis must find a way to become lawful permanent residents or green card holders. U.S. citizens can sponsor some family members for permanent residence, including spouses, parents, children, regardless of if they are married or single, and brothers and sisters. Lawful permanent residents can sponsor their spouses and unmarried children. In some circumstances, employers can sponsor their employees, and international businesses can sponsor their managers and executives. Individuals with extraordinary ability or who do work in the national interest of the United States can self-sponsor for permanent residence. Also, refugees and those with political asylum can file for permanent residence. Finally, every year, the U.S. conducts a visa lottery to diversify the immigrant population in the U.S. and grant 55,000 green cards through that program every year. The status allows individuals to permanently reside in the U.S., to return to the U.S. after temporary international travel without the need for an additional visa, and to receive Social Security and Medicare in retirement for 7 years. In most cases, being in lawful permanent resident status is a prerequisite to becoming a U.S. citizen through the naturalization process.
What is naturalization?
Naturalization is the process of becoming a U.S. citizen through application. A person who has been a lawful permanent resident for at least 5 years, 3 years in the case of a spouse of a U.S. citizen, who has been a person of good moral character during that time, and who has spent sufficient time in the U.S. can file to become a U.S. citizen. The person must be willing to swear an oath of allegiance to the United States, must demonstrate proficiency in English, reading, and writing, and must show that he or she has conducted himself or herself properly while living in the U.S. Naturalized U.S. citizens have virtually all the same rights as those who are U.S. citizens by birth. A person who's been convicted of a crime prior to filing for naturalization may have to wait up to 5 years after the commission of the offense before filing, even if that offense is not one that would lead to removal or deportation from the U.S.
What is removal?
Removal is the technical term for what we commonly refer to as deportation from the U.S. A person can be removed from the U.S. for a variety of reasons, including criminal offenses, fraud, visa or status violations, such as working without authorization, dropping out of school or overstaying a period of admission, entering illegally, and some others.
What is admission?
Admission is the process of seeking entry into the U.S. It has also been expanded to include the process of becoming a permanent resident in some circumstances. To seek admission to the U.S., a person must establish that he or she is admissible under the statute. Criminal record, drug abuse, communicable disease, fraud, prior deportation from the U.S., and many other things may render a person inadmissible to the U.S. When assessing a person's immigration consequences of criminal activity, both admissibility and removability must be considered.
What constitutes a conviction?
Prior to amendments to the Immigration and Nationality Act in 1996, the definition of conviction was the traditional one we all know. For immigration consequences to flow from criminal liability, the conviction had to be final. Under amendments in 1996 to the INA, that definition was changed to close a perceived loophole in the law that allowed immigrants facing criminal proceedings to avoid the immigration consequences of their criminal activity by taking a deferred adjudication under Texas law specifically, since Texas was the state that was under scrutiny when Congress was considering the amendment, or some analogous dispensation in another jurisdiction. For example, under the old law, deferred adjudication and other such programs were not final as long as a final adjudication of guilt was withheld while the defendant went through some type of probation. Congress eliminated the Supreme Court imposed finality requirement by defining conviction as: the term conviction means, with respect to an alien, a formal judgment of guilt of the alien entered by a court, or if adjudication of guilt has been withheld, where 1. A judge or jury has found the alien guilty, or the alien has entered a plea of guilty or dolo contendere, or has admitted sufficient facts to warrant a finding of guilt, and 2. The judge has ordered some form of punishment, penalty, or restraint on the alien's liberty to be imposed. You may be able to see from the language how the law was specifically crafted to address the loophole that was Texas's deferred adjudication process, as well as other similar options in other jurisdictions. The effect of the current definition is to take away the usefulness for a non-citizen of the deferred adjudication and other plea bargaining processes, valuable negotiation tools in the hands of effective criminal law practitioners to minimize costs for the client and to avoid the risks of going to trial and facing time in prison. You must be aware that if your client takes deferred adjudication or some other pre-adjudication probation on a plea of guilt or no contest, it is treated the same as a conviction for immigration purposes. It must be disclosed on all immigration forms as a conviction, meaning you cannot advise your client who has taken this option that he or she does not have to disclose the offense because it will have been ultimately dismissed. Immigration law treats it the same as a finding and judgment of guilt from a court. Some of my criminal law practitioner colleagues have used a pretrial diversion strategy to get around the plea that creates the conviction. If your local district attorney's office has such a program, you should consider that for your client. Under current law, a pretrial diversion program is not a conviction because there is no formal plea and no judge-imposed punishment.
What is a sentence to a term of imprisonment?
In immigration law, the sentence to a term of imprisonment is the amount of time ordered to be served, regardless of any suspension or probation of that sentence. The statute reads, "Any reference to a term of imprisonment or a sentence with respect to an offense is deemed to include the period of incarceration or confinement ordered by a court of law, regardless of any suspension of the imposition or execution of that imprisonment or sentence in whole or in part." For example, if a person is ordered to serve 1 year and 1 day in prison, suspended on successful completion of a series of conditions, such as community service, payment of a fine, rehabilitation classes, etc., the suspension is disregarded when addressing immigration consequences under the INA. That person is considered to have received a conviction with a sentence of 1 year and 1 day. Additionally, you should note that in some situations, the maximum possible penalty for an offense is what's important to a determination of liability under the INA and must be considered. When assessing removability and inadmissibility, these definitions must be taken into account.
Crimes involving moral turpitude. Definition.
There is no statutory definition of a crime involving moral turpitude, or CIMT. Because the statute does not define what it is, the definition is left to the courts. The Board of Immigration Appeals, the U.S. Attorney General, and various federal courts have combined to give us some idea of what the phrase means. A CIMT is considered to be an offense that, quote, refers generally to conduct which is inherently base, vile, or depraved, and contrary to the accepted rules of morality and the duties owed between persons or to society in general, close quote. The U.S. Attorney General has held that the determination breaks down along the lines of scienter. Offenses which do not have as an element reckless, knowing, willful, or intentional behavior are generally not CIMTs. So, for example, Strict liability crimes, or offenses which do not have a scienter requirement for liability to be found, only facts, are not generally CIMTs. In some jurisdictions, this would include DWI or DUI, writing a hot check if no intent to defraud is required under the statute, and there are other examples as well. Regulatory offenses, or statutes that criminalize otherwise acceptable behavior with imposed restrictions, are not generally CIMTs because under the right conditions the behavior is not considered criminal. Common examples are possession of a firearm, sale of tobacco or alcohol, public intoxication. Under some circumstances, these activities are acceptable, such as if you have a license to carry a firearm or you have a permit to sell alcohol. The fact that they are regulated does not change the behavior from acceptable to morally reprehensible simply because that regulatory restriction on otherwise acceptable behavior has been violated. Finally, offenses that would generally be considered minor offenses are frequently not considered to be CIMTs, even with a scienter requirement. Some examples may include offenses like disorderly conduct, simple assault, simple possession of a controlled substance, vagrancy, these kinds of offenses.
Types of crimes that generally are CIMTs. Theft.
Most theft offenses have an intent to deprive element, and generally even low-level shoplifting type minor offenses will be considered CIMTs. Shoplifting, possession of stolen goods, fencing, just a few examples of offenses that have consistently been held to be CIMTs.
Fraud.
Offenses with an element of fraud almost always are CIMTs, including credit card fraud, government benefits fraud, securities fraud, fraud in the sale of a vehicle. These have consistently been held to be CIMTs.
Domestic assault.
Domestic violence, child abuse, child endangerment, child abandonment. These will frequently turn on whether there is a specific intent to harm or injure for determination of whether or not the offense is a CIMT. In some jurisdictions, threatening behavior alone without specific intent to injure may not be CIMTs.
Drugs with intent to distribute or manufacture.
For drug offenses to be CIMTs, something more than simple possession must also be charged. Intent to distribute, manufacture, sell, transporting large quantities. These are generally held to be CIMTs.
Sexual offenses.
As a general rule, a crime that has a sexual element is going to be considered a CIMT as long as there is some required mens rea as well. Strict liability crimes, such as indecent exposure, which in some jurisdictions does not require a showing of intent for liability, generally are not. The big exception to that statement is statutory rape, which has consistently been held to be a CIMT. That is because a minor is involved as a victim, and because there usually is an intent requirement as to the sexual behavior itself, but strict liability as to the minority of the victim.
Property offenses.
Arson, identity theft, embezzlement, these kinds of offenses are generally held to be CIMTs.
Why does it matter?
CIMTs, under certain circumstances, can result in a non-U.S. citizen's removal from or inadmissibility to the U.S. If a person is convicted within 5 years of the last admission as defined in the INA to the U.S., and if the offense has a maximum possible penalty of at least 1 year or more in prison, the person is removable from the U.S. The sentence period is not relevant to this provision. That's really all it takes. A CIMT with the maximum possible penalty being at least 1 year in prison within 5 years of admission as defined in the INA to the U.S. Additionally, 2 CIMTs at any time, regardless of how minor, will render a non-U.S. citizen removable from the U.S. So 2 minor misdemeanor theft offenses, for example, will generally make the person removable from the U.S. regardless of the time served. Additionally, a person is inadmissible to the U.S. if they have 2 convictions for CIMTs. One CIMT can be excused under the petty offense exception if the offense has a maximum possible penalty of 1 year or less in prison and the sentence for the offense was 6 months or less. So, for you criminal law practitioners, your goal for your client should be to have the charge have as a maximum possible penalty no more than 1 year in prison, and to make sure that whatever sentence is handed down, regardless of any suspension, is no more than 6 months. Otherwise, the person will be inadmissible to the U.S., which affects his or her ability to become a permanent resident as well as enter the country.
Aggravated felonies. Overview.
A non-U.S. citizen is deportable from the U.S. if he or she is convicted of an aggravated felony as defined in the INA. You will find the aggravated felony list in INA Section 101A43. It is a long list of offenses, and frankly, they do not necessarily have to be terribly serious to be considered aggravated felonies. Aggravated felony convictions generally, with some very rare and difficult exceptions, leave a non-U.S. citizen with no options to remain in the U.S. That can be pretty harsh when you consider how broadly the INA defines conviction.
What is an immigration aggravated felony?
To be an immigration aggravated felony, the offense does not have to be a felony under the law of the jurisdiction responsible for the conviction. Let me repeat that. The offense your client has been charged with does not have to be a felony level offense under state law for it to be classified as an immigration aggravated felony. Moreover, it does not have to be aggravated in the traditional sense of the word to be an aggravated felony for immigration purposes, like aggravated robbery or aggravated assault. The INA has its own definition of what offenses are considered felonies and what offenses are considered aggravated. So there are no shortcuts. As a criminal defense attorney, you must compare the elements under which your client has been charged to the corresponding aggravated felony definition in the INA to analyze whether or not that will be considered an aggravated felony for immigration purposes. In addition, you must analyze the elements of the corresponding federal offense, if any, against the state statute for a case tried in state court. If the elements of the statute under which the person was convicted in state court would have been a felony under a corresponding federal criminal law, the immigration consequences will be determined based on the federal statute, even if not tried in federal court, not on the state statute.
Most common aggravated felonies. Sexual abuse of a minor.
Any offense related to sexual abuse of a minor is going to be considered an aggravated felony for immigration purposes, almost certainly. It does not matter what it is called: indecency, solicitation, it makes no difference. EOIR will look at whether or not the conviction involved sexual abuse of a minor, regardless of the terms. EOIR will look to the elements of the offense. BIA and the federal district courts have defined this section very, very broadly. In one case, as an example, the defendant in the criminal case was chatting online with a police officer who held himself out to be a 14-year-old girl. The defendant set up a meeting and was arrested at the meeting place. So, there was no sex, no minor, and no abuse. Nevertheless, he was found to be an aggravated felon under this section and deported.
Illicit trafficking in a controlled substance.
You may be surprised to hear that trafficking is not a required element of the criminal case for a drug offense to be considered a trafficking offense for aggravated felony purposes. In fact, any felony punishable under the Controlled Substances Act, 21 U.S.C. Section 921, generally will be considered an immigration aggravated felony.
Crime of violence.
I don't think that it would surprise you that murder and rape are aggravated felonies under the INA. But any crime of violence, as defined in 18 U.S.C. Section 16, for which the sentence to a term of imprisonment is at least 1 year, is also an aggravated felony. It does not matter that the offense may be a minor one. As long as the sentence, regardless of any suspension, deferral, or probation of that sentence, is at least 1 year in duration, and the definition of crime of violence applies to the offense, it is an aggravated felony for immigration purposes. The term crime of violence means an offense that has as an element the use, attempted use, or threatened use of physical force against the person or property of another, or any other offense that is a felony and that by its nature involves a substantial risk that physical force against the person or property of another may be used in the course of committing the offense. This is a very broad section of law and has been applied to assault crimes, burglary, kidnapping, sexual abuse, trespass, unauthorized use of a motor vehicle, and many others.
Theft.
A theft offense, including receipt of stolen property or burglary offense, for which the term of imprisonment is at least 1 year, will be considered an aggravated felony for immigration purposes. Again, it does not have to be a felony under the jurisdiction responsible for the criminal charge. All that matters here is the term of imprisonment, just like with the crime of violence. If your client gets a 1-year sentence or longer, and it's an offense related to theft, it's going to be considered an INA aggravated felony.
An offense involving fraud or deceit.
An offense that involves fraud or deceit in which the loss to the victim or victims exceeds $10,000 will be considered an aggravated felony under the INA. If there is an element of fraud in the statute of conviction, an offense qualifies under this section as long as ICE can prove that the loss to the victims exceeded $10,000. EOIR and BIA will generally look to the restitution amount as a highly persuasive figure in assessing loss to the victims.
Attempting or conspiracy to attempt.
An attempt or conspiracy to attempt any of the listed aggravated felonies under the INA will itself also be considered an aggravated felony. Some other examples of aggravated felonies are counterfeiting, alien smuggling, perjury, tax fraud, and there are some others as well. Before allowing a client to take a plea agreement, it is imperative that you review the aggravated felony section of the INA to make sure you are not letting your client plead guilty to an INA-defined aggravated felony.
Why is it important to avoid these convictions?
Aggravated felonies have severe consequences in immigration law. A non-citizen found to have committed an aggravated felony as defined in the INA will be precluded from asserting most defenses otherwise available to them. Under most circumstances, individuals convicted of an immigration aggravated felony have no options to stay in the U.S. or come back to the U.S., regardless of family ties, previously clean record, payment of taxes, property ownership, etc. None of those factors are even relevant to the analysis. They are deportable and will probably be barred from reentry.
Other problematic offenses. Drug offenses.
Any offense for possession of narcotics, other than simple possession of 30 grams or less of marijuana, will render the person deportable and inadmissible to the U.S. Except under very limited circumstances, drug offenses are the kiss of death for a non-U.S. citizen. Deportation is basically inevitable. It's that simple.
Prostitution and trafficking in drugs or persons.
Prostitution and trafficking offenses are treated very harshly under the INA. Not only are these offenses considered crimes involving moral turpitude, they also can render a person inadmissible to the U.S.
Firearms offenses.
I'm quoting from the INA here. Any alien, and by alien they mean non-U.S. citizen, who at any time after admission is convicted under any law of purchasing, selling, offering for sale, exchanging, using, owning, possessing, or carrying, or of attempting or conspiring to purchase, sell, offer for sale, exchange, use, own, possess, or carry any weapon, part, or accessory which is a firearm or destructive device in violation of any law is deportable. Firearms offenses are not generally crimes involving moral turpitude, so Congress created a special ground of deportation for them.
Domestic violence and child abuse.
I'm quoting from the INA. Any alien who at any time after admission is convicted of a crime of domestic violence, a crime of stalking, or a crime of child abuse, child neglect, or child abandonment is deportable. For purposes of this clause, the term crime of domestic violence means any crime of violence, as defined in Section 16 of Title 18 United States Code, against a person committed by a current or former spouse of the person, by an individual with whom the person shares a child in common, by an individual who is cohabitating with or has cohabitated with the person as a spouse, by an individual similarly situated to a spouse of the person under the domestic or family violence laws of the jurisdiction where the offense occurs, or by any other individual against a person who is protected from that individual's acts under the domestic or family violence laws of the United States or any state, Indian tribunal government, or unit of local government.
Removal proceedings. Removal from the U.S. INA Section 237.
Removal is the technical term for deportation from the U.S. A person is removable for being convicted of a CIMT within 5 years of admission if at least 1 year in prison may be imposed, for an aggravated felony conviction, for alien smuggling, a conviction for domestic violence, or violation of a protective order, for controlled substances offenses other than a single offense for simple possession of 30 grams or less of marijuana, and for firearms offenses. There are many other grounds as well, such as violating visa status, committing fraud at entry, ties to terrorism. These grounds can be found at INA Section 237.
Inadmissibility. Removal under INA Section 212.
A person is inadmissible to the U.S. for having been convicted of a CIMT, meaning that person will find it difficult to enter the U.S. after a conviction. As long as the person has only one CIMT conviction and the maximum possible penalty for the offense was no more than 1 year in prison, and the person was not sentenced to more than 6 months, then he or she may still be admissible to the U.S. Controlled substances, alien smuggling, and prostitution-related offenses will also make someone inadmissible to the U.S. Some of these offenses have waivers or pardons available to them, but some do not, including the controlled substances offenses. An exception to that is a single offense for simple possession of 30 grams or less of marijuana, which may be able to be waived.
Notice to appear and court jurisdiction.
A person subject to removal proceedings is served with charges. The charging document is called a Notice to Appear, or NTA, and it will give specific reasons why the government believes the person is deportable from or inadmissible to the U.S. The NTA is filed with the OIR, and a hearing is scheduled in immigration court. Pleadings are taken, and the court will find that either the person is removable or is not. If the person is found to be removable, he or she will either need to plan to leave shortly after that finding, or else must seek relief from the court.
Relief from removal. Overview.
Under some circumstances, even with a criminal record, a non-U.S. citizen may be able to get relief from deportation and stay in the U.S. Your job as criminal defense counsel is to help your client protect these options as best as possible. I will discuss just a few of the most common weapons we have as immigration practitioners to try to keep our clients in the U.S. and avoid being deported.
LPR through marriage or other relationship.
If the person in removal proceedings is married to a U.S. citizen or has some other qualifying relative petitioning for them, we can try to get a green card for them from the immigration court. However, if the person was previously a lawful permanent resident and was convicted of an aggravated felony, it is not likely that this option will be available to him or her, regardless of their relationship to a U.S. citizen.
COR for LPRs.
If the person in removal proceedings is an LPR and is facing removal for a criminal offense, he or she might be eligible for cancellation of removal. This relief is a waiver or pardon for the criminal issue, and if granted, allows the person to remain in the U.S. as a lawful permanent resident. The person must establish first that he or she has been an LPR for at least 5 years, that they have been in the U.S. for more than 7 years in any status, and most importantly, that they have not been convicted of an aggravated felony. We show that they have been otherwise good people, have family ties to the U.S., rehabilitation and remorse for the criminal behavior, and DOIR will determine whether or not to allow them to stay in the U.S. A person can only get this relief once. One critical issue is that the 7 years presence requirement in the U.S. stops accruing when an offense that subjects the individual to removal from the U.S. is committed. That could be a consideration when you are trying to help an LPR dispose of a criminal case. Pleading may not be an option if the stop time rules were to apply in the event of a conviction that would cause your client to fall short of the 7-year requirement. For example, if your client entered the U.S. in 2002 and was charged with committing an offense in 2008, pleading to that offense in 2010 may cause them to fall short of the 7-year requirement because the clock would have stopped in 2008.
COR for non-LPRs.
Those who are non-LPRs can also fight deportation through COR if they have been physically present in the United States for a continuous period of not less than 10 years immediately preceding the date of the application, has been a person of good moral character during that period, has not been convicted of an offense, and establishes that removal would result in exceptional and extremely unusual hardship to the person's spouse, parent, or child who is a U.S. citizen or an LPR. Obviously, a person in this situation cannot have been convicted of an offense and still have this option available to them. Having to plead to something will foreclose them from this section most likely, unless it is very, very minor.
Political asylum.
Those who fear persecution because of political beliefs, religion, race, national origin, or other qualifications, if they were to return or to be returned to their home country, can be protected through the political asylum program. However, if they have been convicted of a particularly serious crime, they will not be eligible for such protection. Aggravated felonies are always considered to be particularly serious crimes, but an offense does not have to be an aggravated felony for it to be considered a particularly serious crime.
Waivers 212H, 212C.
Under some circumstances, offenses can be waived or pardoned through a showing of extreme hardship to qualifying U.S. relatives, including parents, spouses, or children who are U.S. citizens or permanent residents. The main issue here is ensuring the non-U.S. citizen does not receive an aggravated felony conviction.
Collateral attack on the conviction.
If all else fails and we cannot find a way to resolve a criminal matter that allows us to avoid immigration consequences, there may still be an ultimate option. We frequently see situations in which non-U.S. citizens have accepted plea agreements without being told of the immigration consequences of their decisions. There may be something you can do to help correct the problem. We call it a collateral attack on the conviction itself. The idea is that a criminal defense attorney can go back to the DA's office with a proposed motion for new trial based on ineffective assistance of counsel or some other constitutional defect in the original proceeding. Usually this happens when immigration consequences have been discovered and no one took those into account when the case was active. The person has already completed jail time in many cases, probation, or whatever the penalty was, and now ICE has come calling for deportation. Since the state already has its pound of flesh, they may be willing to help the defendant avoid immigration consequences no one really understood would result from the plea agreement. Because of the recent decision from the Supreme Court in Padilla v. Kentucky, if you are going to try to help someone in this way, it is critical that competent immigration counsel be involved in the process. Every jurisdiction has different rules under precedent case law for what kind of reopening will be considered acceptable in immigration court. For example, BIA will not consider a reopened and repled criminal case to be binding on it if the sole purpose for the reopening was to avoid immigration consequences. You want to see in matter of Pickering, 23 INN decisions, 621, BIA 2003.
Footnote.
Due to the court's recent finding in Padilla, stating that an alien defendant has the right to be informed about the immigration consequences of his or her criminal proceedings, it is presently unclear how this recent ruling, as of August 2010, will impact the prior ruling in matter of Pickering on which the current BIA position is based.
Things an immigration attorney can provide. Advisory opinion.
Immigration attorneys can prepare advisory opinions for you to use in your negotiations with judges and district attorneys. They typically involve a rendition of the facts, summary of the relevant immigration statutes, and suggestions for possible resolutions that will either minimize or eliminate immigration consequences. My colleagues on the criminal defense side report that these are very helpful in developing their strategies for how to represent their non-U.S. citizen clients and also in their negotiations with government attorneys and judges.
Expert testimony in sentencing.
Immigration lawyers can be a good source of expert testimony. allowing everyone, including the government attorneys, judges, juries, involved to hear what the consequences of their decisions will be on the person's immigration status, depending on the punishment that is ordered.
Representation in removal proceedings.
Finally, if your non-U.S. citizen client is placed into removal proceedings, these proceedings frequently happen without the person being allowed to leave detention due to an ICE detainer or hold being placed on him or her while the criminal case is pending. Under some circumstances, those holds can be lifted, but it is very rare. If, despite your best efforts, the non-U.S. citizen is ultimately convicted of an offense under whatever definition, it is probable they will not leave detention. They will be transferred from the local jail to the immigration jail when the criminal case is resolved. Having a relationship with a competent and experienced immigration attorney capable of representing clients in difficult removal proceedings would be invaluable to help you and your client deal with the transition out of criminal proceedings and into immigration court.
Things an immigration attorney can provide: advisory opinion, expert testimony in sentencing, and representation in removal proceedings. Conclusion.
In this presentation, we have reviewed various terms of art and highlighted specific areas of immigration law you need to be familiar with if you intend to represent non-U.S. citizen clients in criminal proceedings. Please don't hesitate to contact an immigration attorney to make sure you do everything you can to protect your client's rights and opportunities, to make sure that client is informed of the immigration consequences he or she is facing. Under Padilla v. Kentucky, it is now your responsibility to make sure that happens. Keep fighting the good fight.
If you have further questions, please contact Mr. Davis at gary@gldlaw.com or call 214-628-9888. In Defense of Immigrants, Criminal Defense Attorney's Primer to Representing Non-U.S. Citizens. www.howtodoimmigrationlaw.com. Copyright 2010 Davis & Willingham, LLC. All rights reserved. This presentation and any ancillary materials are general, educational, and informative in nature and should not be considered legal advice. Although we believe the information provided was accurate at the time it was prepared, we make no claims, promises, warranties, or guarantees about the accuracy, completeness, or adequacy of the information contained in this program. Immigration law changes regularly, and this program is not to be used as a substitute for your own study and analysis. Additionally, an individual's facts and the jurisdiction applicable to a particular case will vary and will affect an individual's options. This program should not be solely relied on in advising a client on how to proceed with his or her case.